The Supreme Court has just stepped directly into a massive constitutional clash that could completely upend how the criminal justice system operates in some states. If you think that your right to a fair trial is completely safe under the Bill of Rights, you need to watch out because the Supreme Court just granted review and will decide a case this term that exposes how the government has been shortchanging your fundamental constitutional protections for over 50 years. This summer, the Supreme Court agreed to take up a fast-moving challenge known as Keon versus the state of Florida. And on paper, this started as a local dispute involving a state licensing issue, but now it has become a question about what the founders of our country actually meant by your right to a jury trial. Currently, 6 different states have been actively bypassing the traditional 12-person jury requirement, convicting individuals using a shrunken 6-person jury instead of the 12. The current conservative majority of the Supreme Court just signaled that they are ready to completely tear down that loophole. And we have a major procedural update. The clock is officially ticking. The opening merits brief has now been filed, and both parties are actively targeting live oral arguments in front of the Supreme Court in December. And now multiple amicus briefs have been filed in support of the Supreme Court reestablishing a 12-person jury under the Constitution. So we need to break down what is happening in this case, what is going on in these briefs, and potentially how this may look going forward. Now, before we jump into this video, if you like this type of content and you want to ensure that you get these videos going forward, make sure to subscribe to the channel and also turn on all notifications so you don't miss these videos when I release them. Now, to understand why this case sent shockwaves through the legal community, we have to look at the bizarre facts that ultimately led this case to make its way all the way to the Supreme Court. Now, the petitioner here is a Florida resident named Mr. Keon, and he was charged by state prosecutors with multiple felony counts of practicing chiropractic medicine with a suspended license. Now, under normal circumstances in a federal court, if you are facing serious prison time, you are guaranteed a traditional and robust 12-person jury to stand between you and the power of the state. But Florida, along with 5 other states, including Arizona, Connecticut, Indiana, Massachusetts, and Utah, have exceptions to that rule. For non-capital offenses, they shrink your constitutional shield down to just 6-person juries. Mr. Keon was forced into a trial before a shrunken 6-person jury, and he was convicted and sentenced to over a year in prison, followed by 5 years of probation. Now, in response to that conviction, Mr. Keon fought back. He demanded that his Sixth Amendment right to a full 12-person jury be respected, and that this ruling and that this conviction was improper because of that shrunken 6-person jury. Now, the state appeals court outright rejected his arguments, pointing to a 1970s Supreme Court precedent called Williams versus Florida. Now, in that older ruling, a past Supreme Court used a cost-benefit analysis, claiming that a shrunken 6-person jury could be equally effective as a traditional 12-person jury. But Mr. Keon's legal team just brought this issue straight to the Supreme Court, arguing that this era of watering down the Bill of Rights is officially over. He argues that the Supreme Court's recent precedent has now changed this rule, and that the Supreme Court should override and essentially overrule that prior ruling that they issued. Now, why did the Supreme Court suddenly grant review to this case? Well, that is because Mr. Keon's petition completely corners the Supreme Court using their own modern logic and recent rulings. In his petition for review, Mr. Keon pointed directly to a massive landmark victory from a 2020 case called Ramos versus Louisiana. Now, in that case, the Supreme Court completely struck down non-unanimous jury verdicts, ruling that the Sixth Amendment must be interpreted exactly as it was understood when the Bill of Rights was adopted in 1791. The court in Ramos explicitly rejected the exact kind of cost-benefit analysis that was used in that 1970s case, stating that it is not the job of judges to decide which historic features of a jury trial are important enough to keep and which ones they can actually discard. Keon's argument goes back to the originalist concepts and focuses on the intent of the founders. He argues that at the founding of this country, the word jury meant one thing and one thing only, a 12-person jury. When the people enshrined that right, they did not attach an exception for future state bureaucrats or for the government to downsize that type of jury trial simply to save time or money. Now, Mr. Keon has officially filed his opening brief in this case to the Supreme Court, and the opening brief makes 2 central arguments. Now, first, Mr. Keon argues that the Sixth Amendment's guarantee of a jury trial must be interpreted according to its original public meaning, and that the historical record overwhelmingly shows a criminal jury meant to actually be 12 people. He relies on English common law, colonial practice, and founding era treatises, and also early state Supreme Court and state court decisions that show that that was in fact the tradition that was in place. He then argues that Ramos versus Louisiana changed the governing methodology by rejecting the kind of functional cost-benefit analysis that was used in Williams, and essentially it rejected that, saying that you could not just weigh these cost-benefit analysis when it applied to a jury trial. Now, second, Keon argues that even if Williams is still technically good law, the court should formally overrule it. He says that Williams was egregiously wrong because it ignored the historical meaning of a jury right in that jury trial, and because its practical assumptions about six-person juries was actually not correct and is not held up. His brief cites research suggesting that smaller juries are less representative, they deliberate less effectively, and they're less likely to include minority viewpoints and may increase the risk of erroneous convictions. Mr. Keon also argues that any state reliance interest in six-person juries in that type of system are limited and cannot outweigh the constitutional right that's currently at stake. And Mr. Keon is no longer making this argument alone. Multiple amicus briefs have now been filed urging the Supreme Court to reverse that lower court ruling and also to overrule Williams. One of the amicus briefs comes from the Florida Association of Criminal Defense Lawyers and the Florida Public Defenders Association. They argue that this six-person jury in Florida emerged during Reconstruction and that Florida is already equipped to return to the 12-person juries. Now, another brief is also notable because it comes from 38 current and former prosecutors, law enforcement officers, and former judges. They tell the court that 12-person juries are not only historically required, but are more representative, that they deliberate more effectively, produce more accurate results, and strengthen public confidence in criminal convictions. Their basic point is that even people whose careers have centered on securing and enforcing convictions, that they are telling the Supreme Court that the legitimacy of those convictions is stronger when 12 members of the community serve on the jury rather than a shrunken six-person jury. Now, this is where this applies to all Americans, especially you as a gun owner. So think about this. If the government is allowed to prosecute complex, high-stakes Second Amendment cases or technical compliance violations before a shrunken six-person jury, it becomes drastically easier to secure a conviction. It takes far less effort to have the state manipulate or pressure six people, or for one person on that jury to impact other people, and you don't have as many voices that are advocating also for you. Also, this impacts your fundamental rights as an American by watering down what protections the founders actually intended when it came to jury trials and what they intended the Sixth Amendment to cover. But now all of this is coming to a head before the Supreme Court, and it will happen before the end of this year. The opening brief has now been filed, multiple amicus briefs have now been submitted, and also now you will see Florida file their response very soon. And it appears that the parties are also targeting oral arguments to take place before the end of this year. So make no mistake, by granting review to this case, the Supreme Court's conservative majority has signaled a massive potential change on a critical constitutional issue. They are poised to declare that states cannot alter, shrink, or dilute the literal text of the Bill of Rights under the guise of administrative convenience, cost savings, or time savings as well. So let me know your thoughts down below in the comment section. Do you think that six-person juries are a dangerous shortcut to potential prison time? Do you think that it violates the Bill of Rights and our constitutional rights? Let me know your thoughts down below in the comment section. But as this moves forward, as we get more information, I will update you guys. So make sure you like, comment, subscribe, and turn on all notifications so you don't miss these videos when I release them. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.